Many thanks for joining us on the bulletin tonight. Now, the Supreme Court has today released the detailed version of its unanimous September 13th verdict upholding President William Ruto's election in the August 9th polls. In the judgment released this afternoon on email, the judges gave a blow-by-blow account on why it dismissed all 9 grounds on which Odinga and 6 other petitioners had sought to overturn Ruto's win. And as Murimi Mwangi now reports, the judges now accuse the Odinga legal team of not only fabricating evidence tabled in court, but also making wild allegations of electoral malpractice against zero proof to substantiate the same.
When the Chief Justice Martha Koome-led 7-judge Supreme Court bench dismissed former Prime Minister Raila Odinga's petition and 6 others challenging President William Ruto's election, the Apex Court did so in what could have sounded as rather unkind words.
We were taken on a wild goose chase that yielded nothing of probative value.
And on Monday, the Supreme Court, in full version of the verdict, sought to explain in detail why the truckload of Odinga's evidence to support his petition could very well have just been hot air across all the 9 issues the court had listed for determination. Among notable arguments fronted by the Odinga legal team, whose dismissal by the Supreme Court majorly took the former Prime Minister's legal team by surprise, was the name of controversial Venezuelan national Jose Camargo, who had been linked to interference plans in the August 9th polls, in addition to further evidence that sought to convince the court that results from some 11,000 polling stations could have been transmitted from a single KEMS kit, with a demonstration by Odinga's lawyer Julie Soweto sampling a polling station in Bungoma and another in Nyeri. In their detailed judgment, the judges specifically revisited Odinga's allegation that on the 10th of August, IEBC had dumped some 11,000 Forms 34A in the portal between 11:01 and 11:09 hours, an allegation the judges said fell flat on its face when the result transmission system was scrutinized in the presence of agents, including one George Njoroge, an IT specialist for the Odinga-led Azimio coalition. The judges summing it up that no evidence was apparent and that it all turned out to be no more than just speculation.
11,000 polling stations that we had complained were staged were transmitted all from one IP address.
We turned to Form 34A for Gasharaigo Primary School, which was sensationally presented by Madam Julie Soweto, advocate. This also turned out to be no more than hot air.
Then there was the evidence allegedly tabled by one Celestine Opio and Arnold Oginga, both of who the Azimio legal team told the court were their agents during the polls, and who in the course of their work noticed discrepancies between Forms 34A handed to them in the duo's respective polling stations and the final copies uploaded in the portal. In their judgment, the judges dismissed the duo's affidavits as inadmissible, as lawyers were not permitted to swear affidavits on behalf of their clients in contentious matters like the one before the court, adding that the Azimio lawyers ran the risk of unknowingly swearing into falsehoods and may be liable to cross-examination to prove the matters deposed. The judges also firing yet another warning shot to famous anti-corruption crusader John Githongo over his controversial yet unsubstantiated claims that 15 hackers based in Karen had manipulated the results on the portal. According to the judges, Githongo's affidavit contained forgeries for not meeting evidential threshold and had not more than just hearsay.
We declare the election of the first respondent as president-elect to be varied under Article 143 of the Constitution.
The Supreme Court decision is final. The Odinga team said though they respected the decision, they did not agree with it, with the Azimio running mate Martha Karua recently threatening to individually petition the verdict at the East African Court of Justice. Murimi Mwangi, KTN News.
And now the detailed ruling by the Supreme Court turns the heat on